used his name, his ID to try and evade officers when I don't think there was anything to evade or obstruct. The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count. A judgment of conviction will be entered today. Argument, Mr. Vila. And if you weren't already going to jail, you are going to jail for sure, such as this, you know? So it's better to be upfront and honest and take your grain of salt when you need to take it, because otherwise it gets worse. And through Assistant District Attorney Jose Vila in person. We have Joel Feliski, Defense Counsel, in person. Mr. Belial appears by video conferencing with approval of the court. We're set here today in this matter for a preliminary hearing. Mr. Belial, your attorney has filed a waiver of preliminary hearing document in the case file. Did he go over that document with you thoroughly?
Yes, Your Honor.
And that's your signature on the bottom of the document?
Yes, Your Honor.
And did you fully understand everything stated on that document?
I did, Your Honor.
Do you understand that once you give up your right, it's forever and you can't get it back?
I do, Your Honor.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No, ma'am, Your Honor.
You're doing so freely, intelligently, and voluntarily?
Yes, ma'am.
I will find that you are competent, you're freely, intelligently, and voluntarily waiving the right to a preliminary hearing. The court will find probable cause and bind the matter over. Information, Mr. Vila.
Thank you, Your Honor. I filed the information. It mirrors the criminal complaint.
All right. Proceed with an arraignment or set it for another date.
Thank you, Your Honor. I'm comfortable proceeding with the arraignment today. I believe that as it mirrors the criminal complaint, that Mr. Belial understands the charge here and the maximum penalties. We'll waive formal reading and enter in a plea of not guilty.
Not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Is this something that is close to a resolution?
Actually, Your Honor, we have managed to reach a resolution in this matter for Mr. Belial to plead to the sole count in the complaint as amended to a charge of obstruction, joint recommendation for costs. So we are prepared to schedule a plea and sentencing at the next available date.
Or if you want to handle it here today, Mr. Belial, I could get it resolved today, but you're appearing by Zoom. So you would have to tell me that you want to waive your personal appearance being in person and have a plea by Zoom.
I would love that.
Mr. Feliski?
I have no objection to that. Then I'm comfortable proceeding as long as Mr. Belial is.
All right.
I am. Thank you.
Mr. Belial, how old are you?
I am 40 years old, ma'am.
Can you read, write, and you understand the English language?
I can, Your Honor.
Any drugs, alcohol, or medications in the last 24 hours?
No, ma'am.
Other than your AODA treatment, any other treatment for a mental illness or disorder?
No, ma'am.
Do you understand that you have the right to have a jury trial? You have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You have the right to testify on your own behalf or remain silent and not have your silence used against you. You also have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights that you're giving up here today?
I understand.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
I understand.
You understand that here the state would have to prove that on or around April 17th, 2026, that while in the presence of an officer that whom you knew was an officer, doing an act in an official capacity and with lawful authority, you failed to abide by the officer's demands or instructions, and or here you provided a false name. Is that accurate? Do you understand what the state would have to prove? Do
I understand.
you understand the maximum possible penalty could be a fine of up to $10,000 or 9 months of incarceration or both?
I understand.
You understand that there is a recommendation for costs only, but I'm not bound to follow that.
I understand.
I could sentence you to the maximum possible penalty if I thought it was warranted. Do you understand that?
I understand.
I also wanted to let you know that if you have any questions or concerns and you need to speak with your attorney during this process, let me know. I'll send them into Zoom and send you to a confidential breakout session, okay?
Okay.
Now, did you go over that criminal complaint with your attorney, that original charging document where it said what happened that day and why you were charged with the crime?
Yes.
For the most part, are those facts accurate?
Yes.
Are you pleading guilty because you are guilty?
Yes. Yes.
Okay. Mr. Flisky, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you for you to plead guilty today, Mr. Belial?
No, ma'am.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, ma'am.
and voluntarily?
Yes, ma'am.
Has your attorney represented you competently?
Yes, he has.
Has he explained everything thoroughly to you?
Yes, he has.
Are you satisfied with his services?
I am.
Any questions for the court or for your attorney before I proceed?
No, I don't.
As to the amended count, will formal motion to amend?
So made.
Granted. As to the amended count of obstructing an officer, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count. A judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. Mr. Belial is here present today taking responsibility for his actions. This isn't the most serious case in the world, given the facts that were presented here. Furthermore, it's my understanding that he is going to be on supervision even outside of this case. Given all those facts, I think this is a more than appropriate resolution. I would ask the court to follow it. Thank you.
Mr. Flisky.
Thank you, Your Honor. I concur with the remarks by the state. I'd also note that Mr. Belial entered into treatment essentially immediately after I began representing him. It sounds like that's something he'd been wanting to do for a while. He's currently at a follow-up program right now in Cameron, to my understanding. Part of the reason that we reached resolution here is that he does want to put this behind him. He wants to be sure to be able to access all the resources and programming that are available in his current location that he would not be able to do so otherwise with this open case. So overall, Your Honor, I do think this is an appropriate agreement. I think costs are an appropriate deterrent, but I would ask the court to follow this agreement. Thank you.
All right, thank you. Mr. Belial, anything you want to state or add here today?
Other than I just want to resolve this and use the resources to better my life, better my chances at employment. I would like to ask, like, on the as far as a deadline on the fine payment, like, is, like, obviously I don't have a job or any means of funds right now. Could you be a little lenient on, like, a payment plan, or just give me a little bit of time to figure out a payment plan?
All right, thank you. Thank you, Mr. Belial. Mr. Belial, in looking at this case and reading the facts behind it, you did a stupid thing. I think Adrian's your brother. I can't recall if he is or what
Yes.
relation. Yeah, he's your brother.
Yeah.
You used his name, his ID to try and evade officers when I don't think there was anything to evade or obstruct?
Just the simple fact that I didn't want to go to jail. That was probably, a stupid decision. I realized that. That's just, I have no one to blame other than myself, and that's just the addiction that want to fix for myself.
And I'm glad that you are doing what you're doing and you're taking the steps to get your life back on track and to gain your sobriety and to gain control over your life. Those are all positive things. And so I commend you for doing those things. Now you can understand, if you didn't already know, it's a crime to give somebody else's name or information to law enforcement when they ask your name. And if you weren't already going to jail, you are going to jail for sure, such as this, So it's better to be upfront and honest and take your grain of salt when you need to take it, because otherwise it gets worse and makes it a whole lot worse. I think that a fine is appropriate in this matter. Well, not a fine. All I'm going to do is the DNA, mandatory DNA cost of $200. I'm waiving $243 of fines and fees, and that's because you're taking care of it right away. You're being accountable and you understand what you did wrong. So $200. I'm going to say, well, first, how long are you in Cameron?
Until September 25th.
Okay, until September 25th. So what I'm going to say is you have until the end of November to pay the $200. Does that work?
Yes, that's pretty good amount of time. I'm currently on the job hunt as we speak, so
if you can pay it sooner, I strongly encourage you do so, because I will issue a warrant and you could sit up to 6 months in jail. And I'm going to tell you, you'll get a warrant, you'll get arrested, you'll be brought here. Or if you don't get arrested on the warrant, I will still make you turn yourself in. Then we'll go over some things to see why you haven't paid. So it's very important that you pay it, and as quickly as you practically can, because then you don't have to worry about being in contempt of court. The court will also enter a civil judgment against you if you don't pay it. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need to order your DNA, check with the Burnett County Sheriff's Department to see if they need it. If they do, they'll take it. If they don't, then you're good to go. So I'm going to say, call them to see within 2 weeks. And if they do need it, then you need to work with them to figure out how to get it. You might be able to do it there in Barron, or I think that's Barron County, and get that taken care of. You have the right to request it be expunged through a written letter to the Department of Justice, not to me, not to the court, but to the Wisconsin Department of Justice. It's easy to do. Google it and you'll see how easy it is, or you can ask your attorney. He can help you if that's what you wish to do. I think that covers everything. Mr. Vila?
I would agree, Your Honor.
Mr. Flisky?
Nothing further. Thank you.
All right. Good luck to you, Mr. Belial. Good luck. Good luck. Again, please get that paid as quickly as you can, and please make sure that you call the Sheriff's Department and you see if they need your DNA and do it whatever way they indicate, okay?
I appreciate it, Your Honor. Thank you.
Are you still on Billy Boy Lane?
I am, yeah, that's my mother's.
And 2560 is the last four of your phone?
That's my mother's phone.
That's fine. That's
Mine.
good. We're good.
Okay.
Your mom's
Okay.
fine. We'll be able to get a hold of her,
Okay.
a hold of you through
Okay.
her. All right.
Okay.
Thank you. We're adjourned.
Thank you.
You're done, Mr. Flisky?
Yes, Your Honor.
Thank you.
Thank you.
Mr. Bruce. We will go on the record in the matter 24 CT 105, State of Wisconsin versus Daniel Bruce. The state appears through Assistant District Attorney Jose Vila in person. Mr. Bruce appears in person without counsel. We're set for a status conference. Mr. Bruce, this is getting extremely old. What do you have left to do?
We're going to get them tomorrow. We're just back in compliance recently because I wasn't engaging with them. So that I had to pay a $206 reinstatement fee to get back into compliance, and that's taken care of. So tomorrow, planning
You're
to
gonna
go to the DMV.
Do it tomorrow.
Right.
Okay, because I'm setting your next hearing date for Tuesday, the 14th at 11.
Okay.
Okay?
Okay.
If you have your license, you're good to go. All you need to do is make sure that the district attorney gets a copy of it.
I think it'll be a print off on paper.
But I think they accept that, right? The
Yep,
print,
that's
you
fine.
don't need the hard copy. You just need to show them that you
Okay.
did get your license, and then you don't need to appear. If there's still some kind of flaw in the system and you don't have it by then you can appear by telephone or video at that hearing. But I'm gonna say, I'm not going to take the, oops, I missed the DMV. Okay, that's
Okay.
not an excuse I'll take.
All right.
Having the DMV say, oops, you need to do one more thing, I'll accept, but not that you didn't go to the DMV and didn't pay the money and didn't get your license, okay?
We're going to knock this out tomorrow.
Good.
All right.
Thank you. If you knock it out tomorrow, then immediately get a copy to the district attorney, and then he will immediately notify the court and the hearing will be removed and you'll be good.
Good.
Okay?
All right.
Thank you.
Thank you.
We're adjourned.
You want me to grab?
Yes, you can get the notice. You, Mr. Durand?
Some instructions on there if you need it.
We will go on the record in the matter 26 CM 62, State of Wisconsin versus Trevor Durand. The state appears through Assistant District Attorney Jose Vila in person. Mr. Durand appears in person without counsel. We're set for a status conference. We were here back on May 27th. And I believe that an offer was presented and we were giving Mr. Durand an opportunity to consider that offer. Mr. Durand, what do you want to do?
Well, I set up an appointment with Dave and I already had a class with him. So I started Monday, and every Monday at 10:30, I got 3 more left.
Okay,
Yep. But they said they didn't have proof here, so that's why I had to come in today. He said I might not have to appear, but
okay. So you still have 3 left to do with Dave?
yep,
And they're weekly, right?
yep.
So let's get you another date. If you complete all 3 of those and we get confirmation that you have completed all 3, you won't need to appear at the next one because the state can just ask to have it amended to that ticket.
Okay,
Okay, and you're covered. You already have bail posted that will cover it and you'll probably get some back, okay?
okay.
Wednesday, August 5th at 9:30, okay? Wednesday, August 5th at 9:30. Again, if you've completed all of the rest of the 3 weeks.
Yep.
And Dave usually provides us proof, but just make sure that completion is provided
All right.
to the state, then you wouldn't need to appear and the state can just amend to that ticket.
Okay.
All right, come get your notice and you're free to go.
Thank you.
Because there's not restitution or anything, right? Any Mary Jane Tucker? We will go on the record in the matter 25 CT 39, State of Wisconsin versus Mary Jane Tucker. The state appears through Assistant District Attorney Jose Vila in person. Ms. Tucker fails to appear. This matter was set for today at 2:45. It is now 2:55 and no appearance. It is a very good weather day, very good driving day, although she does not have her own license, I don't think. because that's what this case is all about. But she may have gotten a ride or call to see if she could appear by video. She has done neither of those. She fails to appear. What is the state requesting? And this is the second failed appearance in this very early case.
I would ask for a warrant, Your Honor.
I guess it's not a very early case, but second time she's missed. So the court will issue a warrant. $500 cash. Only judge may quash or posting of the cash. She will be provided a new date and time upon posting. The court will forfeit the cash previously posted pursuant to 969.13 of the Wisconsin statute. And for the record, she did have actual and oral notice of today's date and time because she did make the last hearing. We are adjourned. We have Attorney Peter Vu, Victims' Rights Compliance.
Yes, Your Honor.
We will go on the record in the matter 26CM05, 26CM50, State of Wisconsin versus David Kisslinger Sr. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Kisslinger in person. His counsel, Peter Vu, appears by video conferencing with approval of the court. We're set for a status conference. I know at the last hearing, Mr. Kisslinger was a little confused about what he needed to do or what he needed to go about doing to meet and the offer of the state. Mr. Vu, can you update the court with regards to this matter?
My understanding, and it appears there was a letter filed with the court a little while ago that says that he appears to have completed domestic violence counseling portion of accomplishing the terms of the offer. There was also the requirement of him doing a mental health assessment. Mr. Kisslinger has been working on that, trying to work with his healthcare providers. He explained to me earlier today that he has figured out a group that can do the mental health assessment. I believe he has that scheduled for July 27th at the end of the month. So I think we need at least one more of these. And hopefully once that's taken care of, maybe we'll be ready to resolve.
Is that correct?
Yes, ma'am.
July 27th?
Right. I have to see the doctor before I could go, so,
Makes sense, and that's fine. And so what I'm going to do is just give you a little bit of time. And I believe the offer is, if he does both of those things and provides the proof, it'll be a plea to a DC with costs without any enhancers or anything. Is that correct? I can't remember whose case this is.
That's my understanding.
Okay. Can you do 3 o'clock on August 3rd?
I have another hearing at that exact same time, Your Honor.
What about 1 o'clock on August 3rd?
1 o'clock. I can make 1 o'clock work, yes.
Okay, so 1 o'clock, August 3rd. Hopefully you have all of those things done by then, and then it would be plead to a disorderly conduct for costs only, okay? Okay, you can come get your notice and you're free to go.
Thank you.
Thank you. We will go on the record in the matters 25 CM 212, 25 TR 660, State of Wisconsin versus Byron Benjamin. The state appears through Assistant District Attorney Jose Fila in person. We have Mr. Benjamin appearing in person with his counsel Daniel Chapman. We're here today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. Chapman, can you please recite the agreement for the record?
Your Honor, Mr. Benjamin will be pleading guilty to OWI second and to operating after revocation. He has completed the intoxicated driver intervention program, or at least a Minnesota equivalent of that. There will be a joint recommendation for the IDIP guidelines on the OWI and for court costs only on the operating after revocation.
Was he arrested and did he sit time?
He sat overnight, but This is a second offense, so the court can give a report date, which we're going to ask for.
Yes, and I was gonna do that anyway. I just wanted to know, sometimes with an OWI second, they've already set their days.
He has, oh, you mean, does he have time served?
Yes.
Not quite, no.
Okay.
He has 2 days credit, which I believe he'll have to sit roughly a day and a half, depending on the release time.
Okay, so he actually wants to sit, doesn't wanna,
He's going to talk to Tessa about the house arrest. It might be worth his time to have it hooked up. He might just want to come in and sit a weekend, depending on how long he has to actually sit.
whatever
talk to
you wanna
Tessa.
do. Yeah, and if the court does follow recommendations, it's 5 days. He has 1 day of jail credit,
2 days.
2 days, 5 days, 1 day for good time, 2 days jail credit, it's 2 days. So honestly, the better deal would be sitting in the jail because you have to be on for 48 hours on the monitor versus they would let you out at 8 o'clock at the next morning. So you talk to your attorney about that.
Yeah,
Okay.
he's going to, we've already talked about it. He'll talk to Tessa if he wants to do house arrest or not.
Okay, sounds good. So that's the agreement that you've reached, Mr. Benjamin?
Yeah.
So you're pleading guilty to an OWI second and an operating while revoked matter?
Yes.
I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document?
Yes.
Did your attorney go over this document with you?
Yes, he did.
Did he go over it thoroughly with you, essentially word for word?
Yes.
And you understand everything completely?
Yes.
Is that your signature on the second page?
Yes.
You're 21, 12 years of schooling. You can read, write, you understand the English language, no drugs, alcohol, or other medications, and no treatment for a mental illness or disorder, correct?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the first page of the plea questionnaire. Your attorney went over those rights with you?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation? I have to say that to everybody. You understand? Do you understand that with regards to count 1, operating a motor vehicle while under the influence, second offense, the state would have to prove on or around August 3rd, 2025 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant. Do you understand what the state would have to prove?
Yes.
Do you understand that upon conviction, you could be fined not less than $350, but no more than $1,100, and imprisoned not less than 5 days, but no more than 6 months?
Yes.
You understand that the court shall order an OWI AODA assessment and all follow through, including a driver safety plan, and shall revoke your driver's license for not less than 1 year, but no more than 18 months, and shall also order that you have an ignition interlock device placed upon your vehicle for the same time as your revocation?
Yes.
As to the operating after revocation, do you understand the state would have to prove the same date, time, and place that in Burnett County, Wisconsin, while being a person whose operating privileges have been revoked pursuant to Wisconsin law, you did operate a motor vehicle during that revocation period or thereafter? Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $2,500 or imprisonment of up to 1 year in the county jail or both?
Yes.
Do you understand that there is an agreement that's been reached and it's been stated and placed on the record? But do you understand that I'm not bound to follow that agreement?
Yes.
That means I could sentence you to the maximum possible penalty for each of those charges if I thought it was warranted. Do you understand that?
Yes.
Do you still wish to proceed and enter guilty, please?
Yes.
Did you go over the criminal complaint with your attorney?
Yes.
In particular, did you go over the probable cause section where it basically says what happened that day and why you were charged with crimes?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today you in fact did operate a motor vehicle while under the influence?
Yeah.
And are you admitting here today you in fact did operate a motor vehicle during your revocation period?
Yes.
Mr. Chapman, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty today, Mr. Benjamin?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing?
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No.
As to count 1, operating while intoxicated, second offense, how do you wish to plead?
Guilty.
As to count 3, operating while revoked, how do you wish to plead?
Guilty.
Court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of count 1 and count 3. Count 4 will be dismissed and read in for purposes of sentencing. Count 2 will be dismissed and merged in with count 1. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Vila.
Thank you, Your Honor. I believe the joint recommendations before the court here are appropriate. Mr. Benjamin did complete the IDIP program. As such, he hopefully took full opportunity to really digest everything he learned so that he doesn't reappear before the court in this manner again. This is an OWI second, so it's a misdemeanor level offense for OWIs, and should he continue to reoffend, he's just going to receive harsher and harsher punishment. Regarding the OAR, it's a lower level offense in the grand scheme of things, and cost is more than appropriate for that. I would ask the court to adopt the joint recommendation. Thank you.
Thank you. Mr. Chapman.
Your Honor, as part of the IDIP, Mr. Benjamin did an alcohol and drug assessment, and he's still engaged in outpatient counseling for alcohol use. He's only 21. I agree that the guidelines are appropriate to make sure everybody is treated equally, and I'd also ask you to follow the recommendation.
All right, thank you. Anything you want to add, Mr. Benjamin?
No.
There is a component of 25 hours of community service. Have you looked into that already?
No, I haven't. No.
You can do it with a tribe, you can do it with a nonprofit, anything like that, or you could convert it to additional jail days. Here, it would be 3 additional jail days. So if you would like to have it on monitor, you can add it and you can serve those on monitor too. You can talk to Ms. Anderson about that and she'll go over that requirement of 25 hours of community service. The court, these are serious because it's an operating while intoxicated and an operating after revocation. However, the revocation portion is not as serious, but together it makes them a little bit more serious. You're doing what you need to do. You're still in counseling and treatment. So I think that's a very positive thing. And I'm glad to hear that. You're going to have to work on getting your driver's license.
Yeah, I've been working towards that.
What do you have to do?
I need the completion of treatment, interlock, reinstatement fee, and fines.
Okay. And so how much fines do you have? How much money in fines you owe?
Not too sure on that, but I think it's like about around 1,000 area, I think.
And is that to Minnesota or here in Wisconsin?
No, Minnesota.
Okay. And so you're actively working on getting your license?
Yeah.
I would strongly encourage you to do it as quickly as you can, because as you can see, things add up.
Yeah.
And if you are driving again without a driver's license, it just continues to make things worse.
Yeah.
Okay. $976 in fines and fees, plus a $10 blood draw fee, 5 days of incarceration, with 2 days of jail credit, 12-month ignition interlock device, 12-month revocation of your driver's license with any credit for any administrative suspension you may have already received. Again, you can convert 25 hours into additional jail days. You can serve your jail on monitor if you wish to do that. Talk to Ms. Anderson, but you have to be extremely careful because the bracelets can't be around like gasoline or rubbing alcohol, because it will set it off, because it tests your skin and any secretions or sweat or anything from your skin for alcohol. And so if you have it near one of those things or anything that has alcohol, it will set it off and it'll say that you're violating. Okay.
Like cologne.
Probably.
I'd be careful.
I'd be very careful. Yes. So, I mean, just put cologne up here and just spray it or dab it or something with your arm the other way. Because if it does indicate that you are violating, you will be told by Ms. Anderson that you must immediately report to jail. You'll be revoked from the monitor. No good time, no Huber. Okay, so it's very important. Just follow all of that and do what you need to do. All right. I will give you 30 days to figure out how you want to report and what you want to do. Okay, you don't have to wait the 30 days. If you are all ready to do everything in 5 days, go ahead, take care of it. The sooner the better. All right. With regards to your fines and fees, you're going to need a payment plan, I presume.
Yes, Your Honor.
Are you employed?
No.
Are you going to look at employment?
Yeah, I've been looking for jobs.
I suppose it's hard without a driver's license.
Yeah.
What I'm going to say is $150 a month. I'll give you a little bit of a grace period so that you can look for a job, etc. First payment is due by the end of August. Okay, so it gives you a couple months, almost a couple months.
Okay.
Okay, so by the end of August,
So you want the payment on August 31st?
that can be, or it can be, you know, I might not chance it August
but-
30th. Yeah, but by then, yeah, at the end of August. So $150 a month, first payment, end of August, and every month thereafter. If you fail to make even one payment, the court will enter a civil judgment against you because you're always going to owe it. I will issue a warrant. You could sit up to 6 months in jail. So it's very important that you make your payment, or if you're having some substantial hardship that came about and you're concerned that you're not going to be able to make the payment, you have to let me know so that I can set up a hearing, a status, so you can tell me what's going on and why you need to have a stay for a month or so, okay?
Okay.
So make sure that you do that. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose. Ms. Landgraf did file a motion to suppress evidence. Are we ready to proceed? Yes. Then Mr. Schmidt, can you please call your first witness?
I call Bailey Mangan.
Deputy Mangan, please raise your right hand. You'll be sworn in and come have a seat at the witness stand.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
All right, you may begin as soon as he's seated.
Could you state your name, spelling your first and last name for the record?
Yes, my first name is Bailey. My last name is Mangan. My first name is spelled Bailey. My last name is Mangan, Mangen.
What do you do for a living?
I am employed at the Burnett County Sheriff's Office as a Sheriff's Patrol Deputy.
How long have you been so employed?
Been full-time with Burnett County Sheriff's Office since December of 2019.
How many total years law enforcement experience do you have?
I started in Siren part-time in February of 2019.
So you've completed the requisite trainings for all law enforcement officers in Wisconsin,
Yes,
and you passed that.
yes,
You've gotten specific training on drug and other interdiction.
yes.
On February 26, 2026, did you meet with a confidential informant?
I've met with a source of information, yes.
Okay. Did that informant give you any information about a subject named Hawaiian Eddie?
Yes.
What did they tell you?
During my contact with that source of information, they provided information about a male who they used a nickname of Hawaiian Eddie. That source provided information that that male was selling firearms or guns. They also used the term dabbling in other things as well.
Did she observe any of these gun sales?
They did observe the gun, yes.
What did she say about a gun she saw?
The source of information stated that they had been at a residence and observed a handgun and had also seen the handgun, had also spoke to the person who purchased the handgun as well.
Did the source say who sold the handgun?
Yes, the source indicated that the male that she described as used the nickname Hawaiian Eddie sold the handgun to Brian Nelson.
And did this person say how much the gun was sold for?
The person provided information that the gun was sold for $150.
Did the sale include ammunition?
Yes.
Was the firearm operable?
The source indicated that they observed or they had seen the gun be fired after it was sold.
How were you able to figure out who Hawaiian Eddie was?
I had shown the source of information a photo of Edwin Akana during my contact with them.
Did they confirm that photo was Hawaiian Eddie?
Yes.
Why did you think to show a photo of Edwin Akana with that description of Hawaiian Eddie?
I had known from previous contacts that Mr. Akana had a long middle name that I guess in my opinion could be construed as Hawaiian.
Did this meeting with this source elucidate information about other issues not related to Edwin Akana?
Yes, several other topics were discussed.
And was the information about other topics accurate?
Yes, I was able to corroborate based off my own knowledge and experience, as well as contacts with individuals and situations that source of information provided about, that the information provided in those other accounts was accurate.
Information about drug interdiction in the county?
Drug activity, yes.
Okay. And what did you do after you got that information?
I did some, I guess, checks. I confirmed that Mr. Akana was on active supervision or active probation out of the state of Wisconsin for felony-related drug charges. I also, in that same check, confirmed what I had already known or had already known about, that Mr. Akana was living with Megan Kurkowski on Alden Road in the Village of Siren.
I guess before I move on too quick, did the source say when this gun sale happened?
Yes, they described the gun sale happening about a week prior to my contact with the source.
Okay. So after you confirmed the address with DOC and the type of supervision, what'd you do next?
It was later in the day, I responded to the residents on Alden Road.
So the same day you got the information from the source?
Yes.
What'd you do when you got there?
I attempted to make contact with Mr. Akana at the front door of the residence. At the front door of the residence, I actually made contact with Ms. Kurkowski.
Did Ms. Kurkowski, what did you talk about with Ms. Kurkowski?
I explained the, I guess, basic reason why I was there and that I was looking to speak with Mr. Akana. I told her that I knew that Mr. Akana was living there. Ms. Kurkowski said that Mr. Akana was not at the residence at the time, but was at work, but that she assumed or knew that he was coming home soon.
So she confirmed he resided there?
Yes.
Did she say whether she knew what he was on probation for?
I don't recall if she said she knew what he was on probation for.
Okay. Did you speak with Edwin Akana prior to going inside the house?
I did, yes.
Did he confirm that he resided there?
Yes.
Okay. Did you enter the house prior to getting a search warrant?
Yes.
What observations did you make of police interest on this entry into the house?
During the first entry into the house, Ms. Kurkowski, I asked her if she could walk me through the house. I had been in other units, but I don't recall ever being in that specific unit. Ms. Kurkowski walked me into the house back towards the bedroom area. In one of the bedrooms that was identified as the bedroom belonging to Ms. Kurkowski and Mr. Akana, I observed a glass bong or glass bubble pipe bong in the closet, as well as a rubber hose hanging on the, like, I guess, dresser mirror thing on the wall. I guess I don't know how to describe it, but.
And based on your training experience, why were these items of police interest?
Both of those items are consistent with items that are commonly used to smoke or consume or inhale methamphetamine or other illicit drugs.
You said this room was identified as both Edwin and Megan's. How?
Miss Kurkowski indicated that that was their room, as well as on the door there was some sort of like lettering that indicated that it was Mr. Akana and Miss Kurkowski's bedroom.
Okay. Did you observe anything else on this first search prior to the search warrant?
I don't believe I did.
Okay. And then afterwards, you obtained a search warrant
Yes,
where you used this information,
yes,
and it was of the same residence.
the search warrant?
Yes.
Yes.
Oh, one more thing I wanted to dial back to when you got the information from the source. Did she say that Edwin Akana only did this one sale?
The source provided information that Mr. Akana, or Hawaiian Eddie at that time, sold guns, is what the information was.
Was there a specific time he would come around?
Yes, the source indicated that Mr. Akana frequented Mr. Nelson's house on Jamesway Road in the morning hours, around 10-ish.
Okay. I think I already asked this, but this was all done the same day. You got this information from the source and then you did the search.
Yes.
Okay. No other questions.
Thank you, Ms. Landgraf.
Thank you, Your Honor. Deputy Mangan, you mentioned the name Nelson, and that is the person that allegedly bought the firearm from Hawaiian Eddie?
That would be his last name, yes.
Okay. Did you speak with Mr. Nelson?
Not prior to this contact, no.
Why not?
I guess I don't have a reason.
Did you have any other corroborating evidence, text messages, pictures, anything other than the source of information telling you this?
About the firearm specifically?
Yes.
No, I did not.
So you spoke with your source, and then based on nothing else, you went to search his residence.
Yes.
And what were you looking for this Act 79 search?
Yes, with the source's information that Mr. Akana, or again, I should say Hawaiian Eddie, because he wasn't identified at that point, but that he sold guns was the information that the source provided.
And did the source say anything about selling firearms out of his residence?
No.
Did the source say anything that my client would have been involved in any way?
There was no mention of Ms. Kurkowski in the actual firearm sale, no.
And you had searched Mr. Akana's vehicle prior to going in the house?
I don't believe we searched the vehicle. I know that he offered consent. I don't recall if the vehicle was searched prior to going in the house, but he was adamant that he offered consent to search his vehicle.
And there were no firearms located?
Correct.
Nothing further.
Redirect.
No.
Right, you may step down.
Thank you.
Any witnesses, any further witnesses? I see none.
Not from the state.
Any witnesses, Ms. Landgraf?
No, Your Honor.
All right, Mr. Schmidt, argument.
I have kind of a tiered argument here, so I'll start first with the first layer. So for Act 79, the standard is reasonable suspicion. That is all that's needed. Deputy Mangan had reasonable suspicion. He had a source who he testified to gave him accurate corroborating information on other similar cases, showing her trustworthiness and reliability. And she gave information about a gun sale that was very specific. She described multiple people who were there, seeing the gun sale, how much money changed hand. He sells multiple guns. This was enough information for Deputy Mangan to have reasonable suspicion Edwin Akana sold a gun, and furthermore, that he had done so multiple times. It is reasonable to conclude that firearms or ammunition might be stored at where you live if you have to put it somewhere if you're selling more than one. The specific information also included information that ammunition went along with it. Furthermore, the remedy being asked for suppression isn't merited here because it doesn't show a violation of a constitutional right. If the argument is that the probationer, the police didn't have sufficient to search the probationer's residence, that argument must fail because for suppression, it has to be a violation of a constitutional right. We know that Act 79 doesn't articulate a constitutional right, it articulates a regulatory framework. So historical argument, prior to Act 79 being passed, DOC always had the ability to search probationers' residences. It was always based on reasonable suspicion. Eventually that went up to the United States Supreme Court in Griffin v. Wisconsin, which I should give a cite to. 483 U.S. 868, 1987. There, the United States Supreme Court commented that probationers enjoy less degree of constitutional protection. They have less of an expectation of privacy because there's a very compelling state interest in having a watch over probationers. Subsequently, the United States Supreme Court in U.S. v. Knights 534 U.S. 112, year 2001, as well as in Sampson v. California 547 U.S. 843 in year 2006, would subsequently hold that even when a court or a law allows search of probationers for any reason at all, even if you don't have reasonable suspicion, it does not violate the Constitution. They just don't enjoy that right. In Wisconsin, we don't have any cases yet on point about Act 79 involving probationer living with non-probationer. What we do have is prior to the Act 79 regime, back when parole was the regime, we have a case about that. That was State v. West 185 Wisdot 2E 68, year 1994, in which our Supreme Court held that searches of parolees' residences over the objection of a non-parolee living in the apartment are constitutional and do not result in suppression. They said that that to hold otherwise would effectively eviscerate the ability to search parolees at all because they could just live with a non-parolee. The court even went further and said that even if procedural requirements of the search warrant are not met, this does not automatically result in justifying the exclusion of resulting evidence. They said suppression of evidence must come as a result of a constitutional requirement, not a procedural one, and that not every procedure embodies a constitutional requirement. Which brings me to one of the things listed in the defendant's motion is they argued the search was arbitrary. It was not. The court heard the specific information. Deputy Mangan acted on it immediately. Even if the court held that it was arbitrary or capricious or harassing as the statute prohibits, that would not be a basis to suppress based on State v. West. Those are not constitutional requirements. In fact, you don't really see those terms in the suppression jurisprudence. You see those more in the lawsuit against the police jurisprudence, which is why Act 79 didn't include a remedy of suppression for a violation of those requirements. So to sum up, the state's argument is there's obviously reasonable suspicion. It was recent specific information from a source that also had other corroborated information. They acted on the same day, which shows it wasn't arbitrary or harassing or capricious. It was acting on information from a source. The remedy of suppression isn't appropriate here unless if the court finds that constitutional right was violated, and based on what's been adduced, that isn't the case because it heard that Edwin Akana is a probationer. He was definitely residing there. Probationers just don't enjoy those rights. The arbitrary, capricious harassing, that didn't happen. It wasn't done in such a manner. In fact, the court heard Megan Kurkowski led Deputy Mangan through, showed him the space. It was a shared space even between Edwin Akana and Megan Kurkowski where the evidence was found. Nothing arbitrary, capricious, or harassing about that. If anything, it was pretty friendly. Furthermore, even if that standard wasn't, the court held it wasn't met, that doesn't result in suppression. Finally, I would do as a final argument, the court heard that a search warrant eventually happened in this case. They searched the house as well. That search warrant included language from the source of information about the gun sale. The state would argue that that information on its own, even if you sever out the drug and drug paraphernalia found on the Act 79 search, was sufficient for the search warrant, and that is another basis to hold in favor of the state. Thank you.
Ms. Landgraf?
Your Honor, could I just have 1 second to confer with my client?
You sure may. If you would like to go outside, we can just totally go off the record for a minute. If you want a little bit more privacy, I'm totally fine if you want to stay here though.
Okay, we'll just step outside.
Off the record momentarily.
I'm just gonna stand because I have back pain.
Ms. Burhow, we do have our 1:30, and maybe you too, Mr. Schmidt, Robert Heath, that's been asked to be moved slightly to a different day. So that one is off.
You said Robert Keith?
Yes, Heath.
Thank you.
Okay.
You're welcome. Why Mr. O'Connor went to prison, I sentenced him. I still can't rely upon that, like you said, and unless it is verified through a source, or perhaps I could have taken judicial notice of that fact, but I didn't need to. Under case law, anyone can ask to have a suppression hearing reopened, even a day or so after the suppression hearing. The court's
3 17-year-olds stood before the judge accused of 2 burglary charges, including the theft of firearms. As the courtroom fell silent, the judge warned that burglary is considered a violent crime and that each defendant could face years in prison if convicted. Looking directly at the teenagers, the judge said they were throwing away bright futures for reckless decisions. Instead of setting an impossible bond, the court ordered strict cash bail, GPS ankle monitors, absolute sobriety, and a complete no-contact order. The judge ended with a powerful warning. 1 violation, 1 excuse, or 1 mistake could send them straight back to jail. This script is based on the hearing from approximately 1:50:48, 2:14:43, where the judge discusses the seriousness of the burglary allegations, prison exposure, bail conditions, GPS monitoring, and the consequences of any future violations.